welcome to our Sparks webinar, in which we'll be discussing the new Digital Operations Resilience Act, why it matters to you as a security leader, and what you should be thinking about right now, even though there's still nearly 2 years before the implementation period is over and enforcement starts. I'm Nick Lyons, a Product Evangelist and Marketing Manager at Panaseer, and I'm joined today by Annick O'Brien, the VP of Operations for CybSafe. Before I let Annick introduce herself, a couple of housekeeping rules, please. First of all, do ask as many questions as you like via the Q&A. We'll aim to answer them either at the end or reach out to you after the webinar. Secondly, please do also join our LinkedIn community. You'll find the details in the description box. And most importantly, let's enjoy the discussion. Over to you, Annick. Do you mind to quickly introduce yourself?
Hi, Nick. Delighted to be here. Thank you so much for the opportunity. So my name's Annick. I am a lawyer by training, so apologies in advance for that. I am really keen on GDPR. It's one of my main passions in life, which is probably a weird thing to say. But I love GDPR because I love the fact that it's a principle-based piece of legislation. And in particular, I'm extremely interested with Article 32, which are the technical and organizational measures, the security clause as it relates to GDPR. And this is so relevant to what we're going to be talking about today in relation to DORA, in relation to third-party risk. I myself work in a cyber role. I am the VP of Operations at CybSafe, and I'm keenly aware at how both law and behavior, as well as privacy, cyber and tech, all interrelate and are really important to work together, not work in silos. And at the same time, it's really important that we take a joined up approach and that we address this early, because I think the key to DORA success, as we're going to see through this discussion, is about getting on the topic early. And whatever we do early will reap its rewards in the end. So I'm keen to talk a little bit more about that and the security provisions in relation to third parties as we go through.
That sounds great. Thanks, Annick. We have set ourselves a challenge not to use PowerPoint for the discussion. After all, it is a discussion. So let's jump in, shall we? As you see, Annick's introduced herself there from a legal perspective. My background, quite literally, as you look around me, is technology. So we're coming at this discussion from different knowledge bases and different perspectives. So let's jump into this Digital Operations Resilience Act, which we'll call DORA from now on. I've waded through the regulation as it stands, which is almost 200 pages, and a few things surprised me. The first thing is it's quite easy to read, even though it's nearly 200 pages long. Annick mentioned it's a principle-based rather than I guess, very restrictive and prescriptive on what you need to do. I just wonder, Annick, if you got any thoughts on, how it's structured and how they've approached this.
Right. Well, this is actually a really good question, because we're seeing in law generally across the vast majority of legal texts that are coming out over the last few years, especially since about 2016, that legal texts are moving away from tick the box requirements and they're moving towards result-based requirements. So they're moving into that sphere of, as I mentioned, principle-based piece of legislation. And what I mean by that is we have legislation which says your objective should be, your result should be, the user should feel, the user should know. And it's in law, it can be that tort concept, which is the idea and the common law concept around, does a reasonable man understand what you're telling him? And this goes right back to, would a reasonable person looking at this document think you've done everything that you can do? Have you put in place reasonable steps to protect the information security at your business, both from a technical perspective and from a people and process perspective? So what's interesting about DORA is that we do see that the legislation is moving towards a principle-based piece of legislation, and it's more focused on results than it is on merely tick-the-box compliance. And we all know that tick-the-box compliance doesn't give us the results we need. And the other thing which is really interesting is I see DORA as a wrap-up of a lot of different types of legislation which we've seen over the last few years, because if we look at marketing regulations that are coming from Europe, or we look at payment services directives, all of them speak about operational resilience. they all speak about digital resilience. So what's really interesting is we've had this mention of operational resilience in all of these laws over the last few years, and now we see it coming together in one very clear act. So I think it's a step forward, and I think we should always take this legislation as a gift, because it enables us to understand what we should be aiming towards, because otherwise we don't know. And then we find ourselves in a sticky situation with a breach or some other issue, and we've had no guidance. So take it as a gift, and let's move on from that topic.
Yeah, no, there's one thing you said there, and I completely agree. There's one thing you said there which also resonated with me around this trying to clear up all the different parts of legislation that have come. There's been a lot of legislation, particularly around financial service industry, that has been implemented at a country level within the EU, or implemented as a directive rather than an act or regulation. So, with this, DORA is a regulation. It is something that has to be implemented. It is mandated from an EU perspective. In its introduction, actually, it does quite clearly state that there's lots of different things that have been happening that haven't necessarily achieved the results, the objectives that they set out. So DORA is trying to clear that up. So I think that's an interesting point you've made. Yeah, the point for me as well is that idea of the principle based, and the principle of proportionality in particular is an interesting one. The Act mandates that the ultimate management structure of a financial institution is on the hook for risk from ICT operations, and must understand the risk that they're accepting as well. But it doesn't mandate how you go about managing that risk technically. It mandates that you continuously monitor your security and ICT performance, but doesn't say how. So I think that's the interesting bit. It tells you what you need to get to, exactly to your point, but it doesn't tell you how you're going to get there. So it's enforcement's going to be an interesting one, and I think your point about explaining to a reasonable person, I think that's a great way of putting yourself in the right mindset to approach this. You've got to be able to defend what you're doing to someone who isn't necessarily deep in the technology, but
totally correct,
be able to understand the risk.
Absolutely, and it's no surprise, of course, that this piece of legislation has been brought in for the financial services, an industry which in itself is accustomed to regulation, is accustomed to requirements, and is accustomed to demonstrable compliance. And I do always say that compliance is not just about doing the right thing, it's about showing that you've done the right thing. So demonstrable compliance is the only form of compliance that's really of any use to anyone. But what's interesting is that it's very wide ranging. So it's not specifically for banks or specifically for other particular institutions who would be used to seeing this type of regulation, but indeed it's for pretty much the entire ecosystem that touches financial services.
There's a couple of things you mentioned there. First of all, the definition of what a financial services institution may be surprising to some people, because it includes, from my limited understanding, it includes things like credit reference agencies, which crowdfunding platforms. It's one of those. I think some people are going to look at this, and if they're not very aware of what the definitions are within DORA, they could be caught out. The impact that this has on third parties is going to be huge. And you can see my background is technology, but there's a whole chapter devoted to third-party risk and the management of that risk. My interpretation of that is there's going to be a lot of contractual changes needed with your third-party suppliers, some of whom will be security vendors, because they're protecting your critical business components. And I just wonder how that's going to play out. Have you got any thoughts on that one, Annick?
Right. So the third-party risk topic is one that people have been challenged with in relation to GDPR and data protection, in relation to exporting data to the US or to China or wherever it might be. This is a challenge that a lot of people have been facing for a long time. And we see it with the developments around Privacy Shield in the US, and we're still not there in terms of what we can safely transfer. We see it in relation to standard contractual clauses. We still don't have a clear way forward of how to use those standard contractual clauses. But taking a step out of the legal, we also were talking earlier about what a reasonable person would see and what a reasonable person would understand. And this is not an opportunity for us to add 18-page amendments to each of our third parties contracts and kind of accept that that's all we need to do, because very clearly DORA is expecting us to be principle-based and results-based. So the amendments to contracts need to be sensible and practicable. And what I mean by that is we need to be looking at the type of service that this third party supplies to us. Are they critical infrastructure, or is it something else? What kind of access to our systems do they have? What kind of access to other software that we use or that we need to use? And what we need to be doing is figuring out what kind of controls and what kind of protections we need to put in place. So there's two elements to that. The first is that we need to put controls in place, and this is in relation to audit. This is time consuming and costly, so this is something we're going to have to think about. Also, third parties and service providers are not going to want us auditing their systems, so we're going to have to figure out how we do this in such a way that we can maintain a good business relationship from both sides. And then the second one is around how we actually make it happen in practice. What are the playbooks for if something goes wrong? What kind of different financial arrangements should we find ourselves in based on these contractual provisions? So there is quite a bit of work to do. And what I would say is that those pesky lawyers tend to take a long time in negotiating amendments to contracts. So if you would start anything now, I would start your review of third parties now to understand who fits into the critical, who fits into the less critical, how easy it would be to swap somebody out in terms of finding a new provider that does the same thing, but also in terms of how embedded they are in your systems, and really understanding which contracts are the ones you're going to have to look at first.
That's great. And I think for me, I'm smiling there because there's also a bit of a tension between, if you've got to negotiate or add amendments to lots of contracts with lots of different vendors, you may be thinking that a strategy might be to reduce the amount of vendors that you're working with, reduce the amount of security vendors you're working with, as an example. But then there's another chapter which is around the not only third-party impact, but also the concentration of risk with third parties, which is mandating again that you cannot put all of your business critical process with a single supplier or a handful of suppliers. And that's almost mandating a multi-cloud strategy, which I think majority of large enterprises already do have. I think Gartner was quoted as saying more than 90% of companies have a multi-cloud strategy, but also gives you an approach to say, actually, we need multi-vendor strategy as well, which means that you've now got these technical controls that we're talking about, whether it's a process control or a technical control around an endpoint or cloud security posture management, you name it, any one of those. Are you concentrating too much risk in a single vendor of those, which again mandates that you've got more places to try and get your information from to continuously monitor the performance of your security tools? So that's a long-winded way of me saying I think there is a tension there between rationalization of vendors and also the concentration of risk in a small handful of vendors. I just wondered, do you have any?
Absolutely. Yeah. No, I mean, it's not a silver bullet to get all of your software or all of your support from one person. What that does is that just concentrates the risk and heightens the risk in relation to that one vendor. Diversification is not a new subject for financial services. Indeed, diversification is required in investments as we currently see it. So diversification when it comes to third parties and infrastructure support will, of course, not be a new topic for the financial services as a whole, but maybe a new topic for the functions within those financial services who have up until now not had any restrictions on who they decided to go for. And maybe depending on the risk profile of your organization, or indeed your approach to procurement, there could have been an approach whereby the cheapest vendor was the one who was chosen, or the vendor who could do single sign-on. That was the most important thing that you were looking for when you were bringing on a third party. And now we have to look at that again. We have to reassess, is this third party still the most appropriate for me? Am I diversifying my third parties in order to minimize risk? And from there, am I really looking at what they can do? One topic, and I'll just talk about this for a moment, is the topic of audit, which came up under GDPR. And audit we see is again present in DORA. And what's interesting about audit is a lot of controllers in the beginning of GDPR understood that they had an audit right and an audit obligation. And therefore, we're really pushing the audit provisions of contracts. And a lot of third parties, a lot of service providers were pushing back on those audit provisions, saying, we don't want you in our business. We're willing to give you information, but we don't want you just coming in for a month every year and going through all of our files. What's interesting about that is I think a lot of people forgot that audit is both a right, and with all rights come responsibilities. So if you have a contract where you've got an audit responsibility, then you do have to demonstrate that you are adhering to that audit responsibility. You have to demonstrate that you have indeed audited your third parties. And I think a lot of people have put contracts in place in 2018 which speak of audit provisions, and now 5 years later have maybe not done proper audit of their critical third parties. And that is a place to start right now, because now we see two pieces of legislation, both GDPR and DORA, who are telling us that we need to audit our third parties. And again, compliance is not just about doing the right thing, it's about showing that you've done the right thing. Demonstrable compliance, you need to be able to show that you have done these audits.
Yeah, that's great. And again, completely agree. And just thinking if our audience are sort of security leaders here, what I hope they're realizing is that there may be external influences that are going to try and change their decision on some of the security tooling stack that they have, to say, well, actually, we're going to change this for simplification reasons, or this particular vendor cannot meet the audit requirements that we're being mandated to put in place by DORA. So takeaway point for me here for security leaders would be understand what this means and start having the discussions right now, as you're saying, with legal, with procurement, to understand how you are going to approach this and evidence this, again, to your point, Annick.
Yep. Well, the data is going to tell us exactly what we need. So in every business, the data of how long these processes take is what will indicate to us how long our compliance program is going to take to put in place and to be functioning in order for the deadline of January 2025. So what I would advise security leaders to do is work closely with your legal and procurement departments to determine how long it usually takes you to find new third-party suppliers, to compare those, to do a tender, to compare them against their own competitors for price and the service they provide, and how long it takes to swap out that third party, how long the contractual negotiations generally take, and then the one that we often forget about, how long does it take for your organization to roll out new software and to have it fully functioning, and for people to be users to be independently working with the software without extensive help from the security or IT department. So if you put those three stages together, when should you start your DORA compliance program? I would say that it's going to take a year to get all of those pieces in place, meaning that you've got until the end of this year to have decided your new third party, to have done your audits and decided whether or not you need to swap anybody out.
Agreed. And I think that's hopefully creating some sense of urgency in education as well, because I think the experience of GDPR, where people were still waiting at, January, February time to say, well, we probably should be doing something, and then finding exactly the enormity of what they've got to do. Hopefully that will create a sense of urgency around DORA.
And the cost. Because a lot of organizations spent a lot of money on GDPR compliance programs. They spent a lot of money on legal fees. They spent a lot of money on new software, and they spent a lot of money on consultants to roll out these programs in their businesses. And a lot of time we do see that compliance programs are not plug and play. You cannot come in with a standardized compliance program to an organization and start to roll it out. You've got to, in order for compliance to actually be a business enabler and to be effective, you have to understand the business value chain. You have to understand the processes that are in place in the organization. You have to understand how your compliance program can work seamlessly and in alliance with those existing processes, to the extent that people are doing what they would do anyway in their job, and they just happen to document one extra piece, or one extra log is taken, which enables you to have your audit, your compliance framework, which enables you to understand where you are and to really understand those metrics and analyze that data. And then if processes need to change, your change management program is restricted down to the processes that absolutely need to change, and changing in a way that still aligns to the business value chain and the objectives that people want to do. Otherwise, we all know you're going to end up with shadow IT. People are going to be circumventing processes, and that's not the objective for DORA, because that in itself creates other challenges.
So that introduces a net new ICT risk, because you don't know about that. You don't know where your data is going. So that is absolutely not the objective here. There's a couple of things you mentioned earlier that I thought was interesting, which is this isn't just a checkbox. I think that is something that is really resonating with me throughout reading DORA. The other thing that resonates with me is that the idea of compliance and audit isn't just point in time anymore. You don't do this once every quarter, once every 6 months, once every year or beyond. This is something that is continuous. You need to continuously show that you are compliant. Well, actually, you need to continuously show that you are managing your associated ICT risk, and that mandates doing this continuously, to use that word again, but that also mandates automation of your checking, of your monitoring, of your compliance, and probably your audit as well. And I think that's something that is a bit of it's a radical change, because audit is seen as something that you have to do every period of time. You have to do when you're asked to. I think DORA is sort of changing it to say, actually, this is going to be something you need to demonstrate continually over time and show your evolution of your security posture and the rationale for evolving your security posture based on data. So that for me is a big change. I don't know if you saw anything around that in your reading.
No, I agree. I think it's a really interesting development that we see across the industry as a whole, not just in relation to DORA, but in relation to other pieces of legislation like NIS2. Recently, when President Joe Biden in the US signed into law the Cyber Incident Reporting for Critical Infrastructure Act, which is in itself a mouthful. But what's interesting about that is these different pieces of legislation are talking about triggers, and they're talking about being continually aware of your situation and having obligations, like in GDPR, obligations to report incidents within a particular time frame, obligations to understand what incidents look like. So there are specific, for example, in the US Act, there's an obligation to report ransomware within 24 hours. This means that you need to understand that ransomware has happened. You need to identify that it is ransomware and not some other type of attack. And you need to know who to report it to, what to report, and how to report it within the time frame, and that's 24 hours. And I have reported GDPR incidents for various different organizations across Europe. And let me tell you, 72 hours is actually really short when you have an incident, and especially if it's not a hugely nefarious incident that has blocked the entire organization from working, but rather it's a smaller contained incident, but it could potentially expose greater risk to data subjects, greater information leakage risks. And that's something that you're trying to do while the entire organization is still running at 100%. So that's a really kind of tricky situation to be in. And what's interesting about DORA is there is this continuous referral to the idea that you should know the state of your ICT affairs. You should be able to understand what the triggers are. And what we see in Article 32 GDPR, taking into account the state of the art, it's the same in DORA. We need to understand what's going on in the world around us. Now, I'm not suggesting, of course, that everybody spends their time online and looking at the different laws that are coming into practice. But it is important that I think you do take some time out and redefine your view on work. And I say this to security leaders, your work is not just being in your business, working on your business, it's also understanding what's going on around there. Webinars like this, if you take an hour a month to listen to something like this, some time to read something, just an understanding, get involved in groups, networking, be involved in channels where you just get pinged on different things that are going on. I know a lot of security leaders do get pinged on different types of security attacks and issues that are going on in the market, so they can know what to look for. And when 0 days come up, a lot of people have that information quite quickly. And we should be doing the same in relation to regulatory requirements, what's going on around the world, what does NIS2 require of us, what's going to be brought into law in the UK, and when's that going to happen? Because all of these things play into the expectation on us and on our business, especially the larger that we are. And of course, if we happen to have parts of our business, if we're not solely UK based, if we have parts of our business in Europe, we are expected to adhere to DORA. And what's interesting about it is, even if we are a bank in the UK and we have third parties in Europe, then we are also required to adhere to this. If we passport financial services into Europe, we are required to adhere to this. So in the same way as the Article 3 territorial part of GDPR, it's very wide ranging. So I would not be tempted to look at it and say that's a European regulation. I'm UK based, therefore it doesn't apply to me. I think you'll find that it does actually apply, and you should be looking now at what elements you should take into consideration in order to build up that strong compliance framework in response to the deadline.
A couple of things I wanted to mention. We talked about accountability and how ultimately the management structure or the board is going to be accountable for ICT risk, and they have to be educated so they can accept that risk and understand that risk associated with ICT and associated threats. One thing I noticed in this, and again, I'm not the legally trained person here, was there is a criminal perspective as well bringing in here, which I don't know what that means. Is that showing some form of personal accountability to the board, or is that something else? I don't know if you've got a perspective on that.
This is a concept that is familiar to financial services. A number of years ago, money laundering became the personal criminal responsibility of directors of certain financial institutions. So a lot of the board of directors of financial institutions will not be surprised to know that there are personal criminal penalties attached to this. This is not new for them, but it's also unhelpful that there's yet another criminal possibility that is open for them if things don't happen the way they should. What's interesting about the education piece in relation to DORA is it's not just about training, and I find that very interesting because we all know that there is a step between awareness and behavior change. So there's a step between training somebody and actually having them understand and having them know. So I always use the example that I know smoking is bad for my health. I know that, but I have not had that internal shift of consciousness whereby there's something that makes me want to actually stop smoking. And it's usually not for my health unless something bad is triggered in my health. But often there are many other things happening in my personal and professional life which make me say, I think I'm going to stop smoking. So we all know that awareness of smoking being bad for your health doesn't necessarily make you stop smoking. Once again, sending out a 25-page memo on information security controls and how DORA can be applied in an organization to your board at the AGM is not sufficient training and awareness and education for them. They need to be involved. And to do that, you need to be able to demonstrate metrics. They do say that if you're not taking score, you're just practicing. So it's important to go to the board with your metrics, with your dashboards, and show them where the risks are, what those risks mean, and let them be involved in understanding and determining which risks are the high priority ones in relation not just to risks as they present in ICT, but risks as they present to the business value chain, to the reputation of the organization, and all of those other important elements that the board do want to be involved in and have great input into. So this is something that I think it's important to remember. And you might have to then have software or take a different approach to how you do report those metrics to your board. Can you get real-time data? Are you able to understand where your organization is in terms of training? What are the click rates in relation to phishing? What do people feel about security in the organization? And because if people don't respect security, then your chances of shadow IT are probably higher. So it's understanding what these metrics mean is another part of it as well.
Indeed, and I'm sitting here as the product evangelist working for a security controls, continuous controls monitoring company, and you've just described exactly what it is we do pretty much there, Annick. So to be able to have that visibility, have that understanding, to be able to measure what your security posture is looking like right now and what the associated risk is to your business, so have the business context associated with that is absolutely critical. That's fundamentally what we help our customers do.
It indeed, it's your technical security, but it's indeed your human cybersecurity risk. Exactly. So it's looking at the whole situation holistically. And I'm not trying to we talk about a sense of urgency. I'm not trying to instill fear here. I do think that organizations have enough time. I do think that this is something that is manageable, but I also think that this is something that we should start to look at the deadline and work backwards from in relation especially to third-party risk and determining how long it's going to take to get these procedures, controls, audits in place, how long it's going to take to negotiate new contracts or to choose new different suppliers, and how long it's going to take to roll out those different softwares or integrate those new suppliers or offboard old suppliers. And I do think that if you look at it from that perspective, and really from a project management perspective, we are looking at the next few months is the period in time in which we should be making those decisions.
Agreed. And I'd make a different point as well. So you're saying third party, again, from the legal, I think, perspective is coming there. For me, the technical perspective is you need to move your compliance and evidencing from being point in time and something that you might run monthly, quarterly, twice a year or annually into something that needs to be continuous. So you're going from a point in time proof to a continuous ability to prove your security posture, so you can understand the associated risk with from the threat of your ICT environment. That moving from a point in time process to a continuous process, that is going to impact not only technology but its people and your processes, exactly to the points you're making there. And for me, that's a big step forward in terms of the maturity of your security posture management approach. So again, that's something that, without wishing to blow our own trumpet, we can help on too. Thank you very, very much for that. I've really enjoyed this discussion rather than death by PowerPoint, because I think it always leads to more interaction for the audience, I hope, or more interesting experience for the audience. Thank you to the audience for your time for listening. Please do, if you haven't yet submitted your questions, please do submit your questions on the Q&A, and we'll be sure to get back to you. And if there's anything we can do to help you in the future with your, or now actually, with your preparations for DORA, please do be in touch.